mental health facility using unethical tactics to coerce voluntary treatment. This is in Central Florida. My significant other has had a recent traumatic experience and took in excessive prescription drugs. She was taken to a mental health facility under a 72 hours Baker Act. At the end of the 72 hours involuntary window, they would need her consent for voluntary treatment or file a BA-32 through the court to continue involuntary treatment. She has repeatedly made it clear to everyone there, including the psychiatrist, that she has a safe environment to return to, family nearby, and she would continue treatment with her therapist and psychiatrist. They got her to sign a paper agreeing to voluntary treatment under threat of Baker acting to her if she did not sign. Saying things like, "You are a smart girl. Work with me on this." They told her she would be giving up her rights by not signing. Every time I call the supervisor to request a date for her discharge from involuntary treatment, they tell me she has agreed to voluntary treatment. After having red flags raised from the general shadiness of this place and the unprofessional employees, I checked reviews and there are pages saying the same thing. Prematurely removing patients who clearly need further care because they do not have insurance. Prolonging the stay of people begging to leave because they do have good insurance. Coercing people to agree to voluntary treatment under threat of keeping them there longer if they do not. Different people there have given us different dates of release between yesterday and Tuesday, with the release repeatedly pushed back. Do I need to get a specialized lawyer involved? Can I call the police and claim false imprisonment to put pressure on them to release her? TL. Doctor. Significant other was brought to mental health facility under 72 hours involuntary hold. They are using unethical tactics to get her signed consent for voluntary treatment beyond 72 hours. I believe this is to continue charging insurance as long as they deem reasonable. If you wish to file a complaint against a licensed healthcare facility regulated by the Agency for Healthcare Administration, please contact us at 1-888-419-3456, 800-955-8771 Florida Relay Service TDD number, or use our licensed healthcare facility complaint form. https://apps.aca.myflorida.com/hcfc/. Found this number on the web and also where you can submit a complaint. I'm sorry this is happening to you and hope you are able to resolve it quickly. This might not address your immediate concern, but if you suspect insurance fraud, waste, abuse, you can report it to your health insurance carrier. It may help this from happening to the next family if one of their coveted good insurance carriers puts them under a microscope. If she signed to voluntarily stay, she can withdraw a voluntary consent. Set the APPT with the outside psychiatrist and therapist. She should pack up. State she no longer consents, and tell them the name of the lawyer. Go and pick her up. Force them to Baker her or let her go. Make sure services are set up and all meds locked up. Have a good safety plan. If she is safe, they have to let her go. If she is not safe, they will Baker her. This may push things to really know if she is safe. Also contact whomever is paying, as they will do a length of stay and stop payment if hospitalization is not necessary. Hospital won't keep without money documents, so when they try to charge you, that a court will side with you. Impossible to know if she needs to be there, but forcing Baker and payment will mean they need to figure it out. She may not be able to out on a weekend. Courts harder to get involved, more likely to make in a conservative order than hold a hearing in. Insurance company isn't open. It is a violation for them to keep her if she doesn't need to be there. The outside people mentioned should be able to independently verify the need, especially if the psychiatrist and therapist had been treating her prior to the attempt. I used to work in a locked psych ward. Have her tell the charge nurse, the administrator, and the psych that she does not consent to further treatment and she would like to leave. Call the insurance company and tell them she has not consented. Withdraw and consent for treatment. Call the sheriff's department and request an escort to pick her up. They may send a deputy to meet you there when you get her. If they aren't going to let her go, they need to demonstrate reasonable suspicion that she's going to attempt to harm herself or others. If they can't show that that's the case, they have to release her. I don't know what rights they're talking about. I've never had a patient get denied by insurance because they left a care facility when they no longer needed care. Edited for clarity, to decrease redundancy. Be aware that voluntary admission is often technically conditional voluntary, as it is called in some other states. For example, in some other states, as I am not familiar with FL, but you should look up the relevant laws. They have it set up so the patient had to give some number of hours or days notice of intent to leave AMA, so as to allow the care team the time to arrange all the necessary outpatient services, appointments, possibly residential care, supportive housing, whatever it is the patient needs, to allow for a safe discharge. It doesn't allow the patient to up and leave on a moment's notice. Basically, it takes into consideration the assumption that whatever treatment the patient had prior to their psychiatric emergency clearly wasn't cutting it and something needs to change to avoid another emergency. Getting all those ducks in a row can take time, especially in an underfunded and overburdened mental health system where getting an appointment can take quite a while, and seats at quality intensive outpatient treatment are sometimes hard to come by, which is why some states have that caveat built in, the give your team X amount of notice part. I am not sure if this applies to Florida, but you should look into it. Voluntary often has some modifiers, conditions. NAL. But I have worked at an inpatient psychiatric facility in Florida in both an administrative capacity and as a therapist. If she refuses to sign and is indeed Baker acted, she will be given a court date, which is held once a week, sometimes more often, but always at least once a week. But before that even happens, she has to be seen by a second psychiatrist that hasn't already seen her, and that individual has to agree with the psychiatrist working with her that being held involuntarily is in her best interest. Both of these psychiatrists will appear in court and they will explain to a judge why they feel her commitment is necessary. She will also get to explain, if she or her family hires a lawyer, they can represent her, more often than not, unless it is obvious that the patient is at risk to harm themselves or others, or there is a significant medication adjustment needed. She will be released. As others have said, in the meantime, complain. Have her tell her nurses and therapists that she demands to see an admin or house supervisor, and then tell that individual she wants to see the person that manages the facility. Keep going up the ladder. Have her advocate for herself. Make threats to go to the people responsible for the facility's oversight and management. Just make sure that she advocates firmly but calmly. Don't give them a reason to notate her behavior as a reason to keep her committed. Don't let them use it as a symptom. Your SO is entitled to retain an attorney. The state bar can help her find one. In the broadest terms, telling someone 72 hours after a suicide attempt that they should voluntarily submit to treatment, rather than go through the legal process of commitment, doesn't really raise much in the way of flags. Nor is it at all surprising that a significant proportion of the people in their care don't necessarily believe they need the care. Your SO should consider working on her treatment rather than fighting it. You may find this Q&A from the Florida Department of Health helpful. It summarizes the Baker Act law for treatment hospitals. Is there such thing as voluntary Baker Act status? Yes. A person can be on voluntary or involuntary status under the Baker Act. However, to be on voluntary status, a person must not only be willing to consent, but competent to consent to admission into treatment. If a person is incompetent to consent to treatment, she can't be held under the voluntary provisions of the law. A person on voluntary status is presumed to be able to exercise all of her rights under the law, including that of consenting or refusing consent to admission and/or treatment. If competent, they could go to any facility they chose, whenever they wished to go, and by whatever means. In such situations where a physician has certified the person's competence to consent, also competent to refuse consent, the individual can then choose whether or not to accept a transfer. If the circumstance isn't considered an emergency, EMTALA wouldn't apply and a destination hospital wouldn't have to accept a transfer even if it had the capacity and capability of managing the person's care. Is a MD allowed to place a 23 to 24-hour hold on patients in a voluntary behavioral health facility? That is, say a patient wants to leave and the MD would like to assess them before they give approval. The question you raise is addressed in the Baker Act as follows. 394.4625 Voluntary admissions. 2. Discharge of voluntary patients. A facility shall discharge a voluntary patient. 2. Who revokes consent to admission or requests discharge. A voluntary patient or a relative, friend, or attorney of the patient may request discharge either orally or in writing at any time following admission to the facility. The patient must be discharged within 24 hours of the request, unless the request is rescinded or the patient is transferred to involuntary status pursuant to this section. The 24-hour time period may be extended by a treatment facility when necessary for adequate discharge planning, but shall not exceed 3 days exclusive of weekends and holidays. If the patient, or another on the patient's behalf, makes an oral request for discharge to a staff member, such request shall be immediately entered in the patient's clinical record. If the request for discharge is made by a person other than the patient, the discharge may be conditioned upon the express and informed consent of the patient. B. A voluntary patient who has been admitted to a facility and who refuses to consent to or revokes consent to treatment shall be discharged within 24 hours after such refusal or revocation, unless transferred to involuntary status pursuant to this section or unless the refusal or revocation is freely and voluntarily rescinded by the patient. 3. Notice of right to discharge. At the time of admission and at least every 6 months thereafter, a voluntary patient shall be notified in writing of his or her right to apply for a discharge. 5. Transfer to involuntary status. When a voluntary patient, or an authorized person on the patient's behalf, makes a request for discharge, the request for discharge, unless freely and voluntarily rescinded, must be communicated to a physician, clinical psychologist, or psychiatrist as quickly as possible, but not later than 12 hours after the request is made. If the patient meets the criteria for involuntary placement, the administrator of the facility must file with the court a petition for involuntary placement within 2 court working days after the request for discharge is made. If the petition is not filed within 2 court working days, the patient shall be discharged. Pending the filing of the petition, the patient may be held in emergency treatment rendered in the least restrictive manner, upon the written order of a physician, if it is determined that such treatment is necessary for the safety of the patient or other. https://www.myflfamilies.com/service-program/som/crisis-services/laws/voluntary admissions adults.pdf embed equals 2 RUKEWJD0KBHG5NSAHV1FJQIHCRX KIBBN USG equals AOV1XU1 RKK7BKGHGQLVN Gosden. Contact your insurance company. Make them aware of the date you wish to pick up your significant other from the facility. For example, tell them to not authorize charges at said facility past this upcoming Tuesday. As soon as the facility knows what's going on, they will give you no problem in terms of releasing your significant other. Dirty scumbags they are. Also, I'd inquire with a lawyer if things progress. Good luck! If she's now a voluntary patient, she should be free to leave. AM 8 against medical advice. Shouldn't she? Or is she in a locked ward? She doesn't need to justify her treatment course or anything. She could maybe ask for a copy of her visit summary to provide to her regular care providers, and then just leave the building. Firstly, hire a lawyer immediately and follow their advice. You can find referrals on the Florida State Bar website. Secondly, if she is there voluntarily, she can revoke her consent, and then the medical facility would either have to release or file for involuntary inpatient care, which they would have to appear before judge in order to get that approved. Quick note regarding involuntary placement: she needs to be absolutely and resolutely clear that involuntary treatment is not necessary. If she is not, it will work against her. I mean absolutely, literally give zero ground. If they file for involuntary placement, or rather before they do this, reach out to her therapist and psychiatrist and ask them if they would be willing to testify on her behalf. You should also ask them to provide a written letter in support of her release. Note, they may or may not be willing to do this and/or might opt for calling the facility instead. A final note: they cannot re-Baker Act her if they attempt to do so. Hire a lawyer, which you should do anyways, but if you didn't hire one immediately. In regards to what kind of lawyer, I would try to find one who specializes in medical malpractices. Malpractice is a complex subject normally, and is even more complicated when dealing with mental health. NAL worked at an inpatient facility for 3 years. Inpatient is used for immediate threat to self or others, along with other things like withdrawal from Xanax, which has seizures associated with it. If the patient is not actively suicidal or in imminent danger, then there is no need for inpatient. They should be moved to partial hospitalization, PHP, or intensive outpatient, IOP, if they truly need to be separated, drugs, or an unsafe environment. Then a halfway house should be used, which is often associated with the facility but much cheaper than inpatient. As someone who did pre-authorizations for years with insurance companies, I can tell you that insurance companies typically won't pay for inpatient unless they actively meet the criteria required to be inpatient, even if that's what the doctor wants. I'd first call the insurance company to ensure that it's all covered. Voluntarily treatment may be considered optional, therefore not covered. They can't keep her, but there may be insurance problems if she is in a PHP program and doesn't complete treatment. Why would insurance pay for someone to complete a few days of a program that a patient withdrew from and therefore has a higher chance of relapse? They often don't. If not careful here, this is a great way to rack up tens of thousands in debt in a few days. Good luck with whatever you decide to do. Key takeaway: if it's not pre-authorized, then have the cash to pay for it because it's not authorized. The insurance company may authorize it later, but it's no guarantee. Get it authorized before the treatment. Follow the program that your insurance company authorized. They may have issues paying for any of it if you don't follow their complete plan. You don't want that financial burden. If anything changes, make sure your insurance company knows ASAP. Lawyer. Now.
If you enjoyed this video, please check out our playlists full of similar content. Epicaricast is like doom scrolling for your ears. Please like, share, and subscribe.